Judges of the New York State Court of Appeals, let the Law Day ceremonies begin. Please rise for the national anthem. Can everyone please be seated?
Good afternoon, everyone. On behalf of my colleagues, Judges Smith, Saparic, Rosenblatt, Graffio, Reed, and Smith, welcome to our Law Day celebration, and a very, very special welcome home to our former colleagues, Chief Judge Wachtler, and Judges Wesley, Levine, and Bellacosa. Welcome to Chief Administrative Judge Jonathan Lippman. Welcome to Presiding Justice Cardona and to the members of the Appellate Division, 3rd Department. Welcome all of you, and thank you all of you for bringing with you this really glorious spring weather so that we can enjoy the great outdoors today. Profound thanks also to the Storm King Brass Quintet of the United States Military Academy for getting these festivities off to such a rousing start, and to our friend, yes, and to our friend Senior Court Attendant Michelle Perry, seated over there, who will once again magnificently conclude today's program. The incomparable privilege of being Chief Judge carries with it the task each year of presiding over Law Day ceremonies. It's one of the many fun parts of being Chief Judge. The occasion, of course, defines itself. Law Day is a celebration of the rule of law that governs this great nation, an annual event initiated nearly half a century ago by the American Bar Association as America's counterpoint to the Soviet Union's May Day display of military might, which was the foundation of its government. And I do love marking Law Day in a uniquely wonderful, traditional American way, with our flag, with red, white, and blue banners and balloons, with stirring patriotic music, and of course, with all of you. In return for originating Law Day and stimulating celebrations across the entire nation these past 48 years, the American Bar Association gets to pick the theme that unites Law Day ceremonies across the nation. This year's theme, of all things, is Liberty Under Law, Separate Branches, Balanced Powers. Seems particularly appropriate this year, doesn't it? As always, the theme provides a good deal of thought and material for what I know will be the inspiring messages of two outstanding lawyers who follow me today, Attorney General Spitzer and State Bar President Bizard. In conversation with our Deputy Clerk, Marjorie McCoy, about my own Law Day remarks, she had the terrific suggestion that I just pick a couple of things I feel passionate about and talk about them. After all, one way or another, everything you can think of can be made to fit under the umbrella of liberty under law. So here is my short list of passions. For starters, like all of you, I am passionate about the American justice system. I'm passionate about our Court of Appeals and the great New York State judiciary, about our separateness, our independence from and parity with the other branches. Indeed, judicial independence has been a cornerstone of American government from this nation's very beginnings. In Alexander Hamilton's words, "There is no liberty if the power of judging be not separated from the legislative and executive powers. The complete independence of the courts is essential." As judges, we are proud of the role that the judicial branch plays and has played throughout the centuries in preserving, protecting, safeguarding our nation's fundamental ideals, of the many struggles that have been fought and won in our nation's courts, because an independent judiciary has the competence and the courage to hew to the requirements of the law, even in the face of controversy and criticism and outright condemnation. Within the judiciary, we are passionate additionally about assuring that the prized American justice system is much, much more than a paper promise, that it remains truly accessible to the public. We are passionate about legal services for those who cannot afford counsel, about making the court process better understood, more user-friendly, about improving jury service and widening jury pools, about educating the public to greater appreciation of the third branch of government. How very sad it is that so many Americans have little understanding of the vital work or role of the judiciary. I am passionate about the people who work in our courts, the people who every single day serve the public so outstandingly, and I am passionate about the people coming into our courts, to whom we owe clean, dignified facilities and effective, respectful attention. And that, of course, most especially includes the bar, which plays such an essential role in the American justice system. Lawyers as counselors and advocates, helping to assure that clients resolve disputes peacefully and act lawfully in pursuing their personal and business objectives. Lawyers as leaders in securing civil rights and equal justice, in public service, in public interest work, in pro bono representation. We are passionate about the judiciary's responsibility to remain attuned to the needs and demands of contemporary society that are reflected on today's dockets, such as domestic violence and drug addiction and mental illness and family law issues. And we are passionate about the children who are before our courts, about doing our part to ensure that they are in safe and loving and permanent families that will allow them to have and to pursue their dreams. Given today's theme, separate branches, balanced powers, on this law day in particular, we celebrate not only the vital separation of the judicial branch in dealing independently with its massive caseloads, but we also celebrate how effective we can be in other respects when we work together with our excellent partners in government. Separate, co-equal branches operating independently, checking and balancing one another, but balanced in another sense as well. We must be respectful of one another's independence, to be sure. Yet each branch is strengthened in its separate role when the three can work together on systemic reform for the good of the public. Only months ago, we had a sterling example of this when we joined in child welfare roundtables with representatives from the executive and legislative branches, the bar, the private sector, to achieve long-needed comprehensive child permanency legislation. And for the past several years, we have labored together to remove systemic obstacles to adoptions for children freed for adoption. and to secure permanency for all children in foster care. I am particularly passionate about the Permanent Judicial Commission on Justice for Children, another marvelous interbranch initiative, this one founded by my predecessor, Chief Judge Wachtler. Today, the commission is focused like a laser beam on the health and education needs of children in foster care, and I am confident that we will continue to make a great, great difference. Too often in government, we share failures. These joint efforts we call sharing success. We look forward to sharing success in other important areas of common interest as well, most especially just now in improving our systems for indigent defense and probation. We are, in short, passionate about identifying and solving the critical issues within the separate and independent purview of the judiciary. We are passionate about cooperating in systemic reform with our partners in government, and we are passionate about having the resources that are necessary to perform all of our essential functions effectively. Passions of the moment, inflamed by fear and ignorance and self-aggrandizement, do not serve the ends of justice. No, justice thrives on passions that are born of shared values and common dreams, entrusted to us by our founders, to be nurtured by each generation and passed on to future generations. In the end, for me, what is most energizing of all, what I am most passionate about, is the opportunity that I have had these precious, treasured years as Chief Judge to join with all of you and to enlarge the circle of dreamers and doers in the service of justice as we labor together to secure the great American ideal of liberty under law. Thank you all so much. It is now my privilege to call upon the outstanding lawyer, our Attorney General, the Honorable Eliot Spitzer, for his Law Day message. Eliot?
Thank you for those kind words, Chief Judge Kay. We are all honored to have been here with you over these years, and we all appreciate and sense your passion for every one of those objectives that you just articulated. Thank you so much. Good morning to all of you. Since this is the 8th year during which I've had the privilege of representing the people of the state of New York, it seemed like a good opportunity to tackle head-on an interpretive issue upon which much depends. Perhaps the most challenging, important, and unfortunately divisive task that confronts us as lawyers is determining how our constitutional guarantees apply in today's world. What freedoms these guarantees protect for individuals, and what limits they impose on government. How does the Fourth Amendment's prohibition of unreasonable searches and seizures, for example, apply to electronic eavesdropping or infrared surveillance? What does the First Amendment's guarantee of freedom of speech mean in an internet age where minors are but one click away from harmful material the framers could scarcely have imagined? These questions are especially tough because the Constitution largely dates to the late 18th century, and its most hotly debated provisions are cast in broad and abstract terms. Since by design, the Constitution is so difficult to amend, it's left to us as lawyers, and especially to judges, to struggle with the task of applying a 200-year-old document to modern life. I like Chief Justice Marshall's approach to this challenge. Back in 1819 in McCulloch v. Maryland, a case most of us read in law school, but now remember only for its primary holding, Justice Marshall described ours as, quote, a constitution intended to endure for ages, to come and consequently to be adapted to the various crises of human affairs. For Marshall, the brilliance of the Constitution is that it was engineered to evolve with the United States, its spare text enlivened by core principles shared by the framers. According to Marshall, quote, to have prescribed the means by which government should, in all future time, execute its powers would have been to change entirely the character of the Constitution. It would have been an unwise attempt to provide, by immutable rules, for exigencies which, if foreseen at all, must have been seen dimly, and which can best be provided for as they occur. This insight seems plainly right to me. As a citizen, as the state's lawyer, I believe in an evolving Constitution. The alternative is one frozen in time, whose protections are interpreted exactly as they were understood on the date they were ratified. Justice Scalia, who once explained that, quote, the Constitution that I interpret and apply is not living but dead, is perhaps the best known proponent of this alternative position. He distrusts jurists' ability to check their personal political preferences in the robing room, fearing that a living Constitution breeds a dangerous flexibility. Under this view, judges, if untethered from the text of the Constitution and the framers' meaning, run amok. In today's vernacular, they legislate from the bench. So instead, judges must read the words of the Constitution to mean what they did at the time they were put on paper, in 1789, 1791, or 1868, as the case may be. Because it is fixed on the past, Justice Scalia's vision is deeply conservative, even reactionary, and one that he himself has said is predicated on the view that the Constitution's, quote, whole purpose is to prevent change. But in my view, our society does mature. Technological changes and scientific discoveries do matter, and the Constitution, anchored by the principles of government articulated by the framers, can take this evolution into account. We must recognize that at least some abstract constitutional phrases, equal protection, cruel and unusual punishment, due process of law, should be interpreted with an eye towards contemporary standards of equality, decency, and justice. If our predecessors, as lawyers, as judges, as legislators, and as citizens, had adopted Justice Scalia's static view instead of recognizing the flexibility built into our constitutional design, we would not have taken some of our most important strides forward as a nation. In civil rights, let's look at some examples. Had the Warren Court been unwilling to look beyond the text of the 14th Amendment as its drafters would have understood it, Brown versus Board of Ed would have been a dead letter and segregation would have remained the norm, just as it was in 1868. Separate but equal would be a mainstay of society, no matter how obvious it might be that separation bred anything but equality. Discriminatory reapportionment schemes would remain unchecked, and restriction of voting to property owners could be in place. Women could still be systematically excluded from juries, and states could still reserve to men alone the unique educational opportunities of a publicly funded college. A state law could legitimately deem a husband the head and master of marital property, free to dispose of it however he may wish without his wife's consent. With respect to privacy, it goes without saying that in an originalist world, there would have been no Roe v. Wade. Nor would married couples, much less unmarried ones, have a constitutionally protected right to purchase or use contraceptives. In an originalist world, criminal procedure would know no Miranda warning, and since the Sixth Amendment never mentions appointing counsel to an indigent defendant, and the practice was not the norm in 1791, Mr. Gideon and others like him would still be forced to defend themselves. As to cruel and unusual punishment, in an originalist world, no one would question the propriety of executing mentally retarded people convicted of capital offenses or juveniles who committed such crimes. At the time the Bill of Rights was adopted, children as young as 7 years old could be executed for felonies. And as to our cherished First Amendment, in an originalist world, the Supreme Court would never have ruled that public schools could not force children to participate in religious observances, or that school officials could not remove books from library shelves simply to prevent students from learning controversial points of view, as such practices were commonplace in 1791. Indeed, as Justice Scalia recently proclaimed, an original understanding of the First Amendment would not impede government from favoring religion over no religion, or for that matter, monotheism over other religious beliefs. Justice Scalia and his originalist brethren cannot persuade me that the original understanding of isolated words laid down on parchment always offers the best guide to interpreting the Constitution and applying it to modern challenges, especially when this approach would so undermine the freedoms we rely upon as a society and rightly laud as the capstone of our democracy. As an interpretive method, originalism simply is not rich enough to sustain our nation through the inevitable march of time and progress. Even Justice Scalia turns his back on it from time to time. For example, he believes that the 11th Amendment shields states from private lawsuits in their own courts, even though this guarantee is not enumerated in the plain text of that provision, which deals only with federal citizen-state diversity jurisdiction. Justice Scalia explains his expansive view in decidedly non-originalist terms. The 11th Amendment should be understood, and I quote, to stand not so much for what it says, but for the presupposition of our constitutional structure, which it confirms. In interpreting this amendment, Justice Scalia is content to leave his 18th century dictionary on the shelf. Originalism also fails when measured against its own claims that the infallible original meaning of text can be divined and that history reveals but one true answer. As Justice Breyer has explained, originalism's exclusive focus on language, history, and tradition, quote, may simply channel subjectivity into a choice about which history, which tradition, and it will then produce a decision that is no less subjective, but which is far less transparent than a decision that directly addresses consequences in constitutional terms. Understanding what the framers meant when they wrote the Constitution can certainly help us in deciphering what its guarantees should mean today. But alone, it cannot be enough. As Justice Brennan observed, and I quote, each age must seek its own way to the unstable balance of those qualities that make us human, and must contend anew with the questions of power and accountability with which the Constitution is concerned. I also take a far more optimistic view of the judiciary than do proponents of originalism like Justice Scalia, who ground their theories partly in a deep distrust of judicial activism. This cynicism is not only misguided, it is contrary to the spirit of our Constitution, which gives judges the independence they need to fulfill their role to serve as a necessary check on the other branches of government. Presumably, the framers who designed this structure trusted judges to exercise this independence with integrity and caution. Judge Kay made a similar point in a Brennan lecture she delivered at NYU over a decade ago. She observed that the humanity of judges, their accumulated experience and wisdom, is not to be quarantined from the business of deciding cases, but that adjudication must also involve what she termed, quote, the Jeffersonian dialogue between head and heart. The common law tradition, so essential to our state courts and the legal fabric of our nation, rests on this understanding as well, and we have seen that the evolving nature of the common law permits state judges to fill interstitial gaps and to respond to the changing circumstances of society, sometimes well before the federal courts. Likewise, a flexible Constitution leaves room for us to consider not merely how the world once was, but also how it ought to be. If originalism were all we had to work with, if the Constitution really committed us to embrace assumptions its framers brought to the table 200 years ago, what could we aspire to as a society? Nor does valuing the aspirational dimensions of our Constitution mean that judges are without boundaries in interpreting its provisions. The well-established doctrine of stare decisis operates to constrain and stabilize judicial opinion-making, as does the structural design of our courts. None of this is to suggest that those of us who advocate an evolving approach to the Constitution don't face difficult questions in translating the Constitution's pronouncements for our modern times. Revealing one theory's flaws is always easier than articulating an alternative. But regardless of the principles one thinks best suited to understanding the Constitution's meaning in a still changing world, those who believe, as I do, that the Constitution, just like its citizens, may grow and evolve, would do well to heed Judge Learned Hand's maxim, and I quote, "It is one of the surest indices of a mature and developed jurisprudence not to make a fortress out of the dictionary." The Constitution retains its legitimacy for ours and future generations, not by shackling us to the mores and missives of men long gone, but by freeing us to realize the enduring principles set forth by the framers. Thank you for listening today, and thank you for 8 glorious law days. It has been an honor and a pleasure.
Thank you, General Spitzer, for 8 glorious law days, and especially for this one, and for your very insightful remarks and your eloquent message. And now I would like to call upon our New York State Bar President, Vince Bizard, for his Law Day message.
Being a part of this Law Day celebration with the members of the court, past and present, with the Attorney General, and with other judges and the leaders of the legislature, and of course with our great Chief Judge, is a once-in-a-lifetime opportunity for the President of the New York State Bar Association. We don't get 14 times or 8 times. We have the most draconian of term limits, the dreaded 1-year term. And I'm sure that there are some public officials here who shudder even to hear it spoken. So I am deeply grateful for this great privilege of being here today and participating, and deeply grateful to Judge Kaye for making it possible, for her careful way that she has set it up as usual, and also for her extraordinary contribution to the legal system and to the organized bar of this state. The law day we celebrate, that is the rule of law in this country, did, as the Chief Judge said, came from the ABA, and from Charles Rhine, who was president of the ABA, the American Bar, in 1958. I had met Charlie Rhine on a number of occasions when he was chief counsel of the National Institute of Municipal Law Officers, and I was corporation counsel of the city of Rochester. He was a very personable, unassuming, courtly, friendly, and I thought at the time, I met him in the 70s, older gentleman who unfortunately now, at that time, was 5 years younger than I am today. But it was a great pleasure to meet Charlie Rhine. And Rhine said that his inspiration for Law Day and having it on May 1st, as the Chief Judge said, was directly related to the Cold War and the fact that the Soviet Union's annual May 1st parade of massive weapons and long lines of soldiers in Red Square made headlines around the world and caused great fear, certainly for those growing up in the 50s, that perhaps the Soviet Union, as Khrushchev said, would prevail and would dominate the world. And Rhine's idea was to contrast the rule of law in the United States with the Soviet Union's rule by repression and force, and he drafted a presidential proclamation which was signed by President Eisenhower in 1958, and we've celebrated Law Day in this country every year thereafter. But the idea of democracy and the rule of law can't be marched up and down Pennsylvania Avenue. But the natural yearning for freedom under the rule of law was far more powerful than the idea of communism and their weapons, and the Soviet Union disintegrated. And what more eloquent symbolism could there be of the triumph of the rule of law than the fact that we are here today at the Court of Appeals, the home of the rule of law in this state, celebrating Law Day and the Soviet Union and their May 1st parades and their entire system have long since passed from the scene. But the ultimate triumph of the rule of law over the Soviet Union is made even more complete by the fact that American lawyers go to the countries of the former Soviet Union and teach them the American legal system and how they may adapt it to their own countries. So Law Day, and that's a symbolism that even Charlie Ryan could not have foreseen back in 1958. So Law Day is a particularly significant day in the life of our country, in the life of our lawyers and our judges, those of us who have the high calling of making the rule of law a reality in the great state of New York and in our nation. The theme this year, checks and balances and the separations of powers, was our founders' way of making sure that democracy would prevail and that power would not be aggregated in any one person or any one branch of government. Nowhere in the Constitution is separation of powers mentioned, and of particular importance to us, nowhere in the Constitution is the judicial review mentioned. And yet, with Marbury versus Madison, judicial review and the power of the Supreme Court as the ultimate interpreter of the Constitution became the foundation of the rule of law in this country, as is the similar power of the Court of Appeals in this state. With the result that no one, the governed or those who govern, are above the rule of law. And that extraordinary fact must seem totally unbelievable to other nations. And the fact is made clear when the Supreme Court found that President Truman in the Youngstown Steel case could not seize the steel mills as he was exceeding congressional authority. And when President Nixon was required to turn over his tape, and President Clinton was required to be subject to civil litigation. And right here in our own state, in Pataki versus Silver, the boundaries of the other two branches was determined. And the point is that the courts of our nation and state provide the place to peacefully make those determinations. The system works because of the judicial independence, the independence of our judiciary, so eloquently described this morning by our Chief Judge. And that if we want to see what independent countries would be without that independence, we need only to look to China, where judges still receive directions from the central power and are disciplined when they don't follow those directions. And today, in Egypt, there are currently riots by judges for judicial independence by their supporters and by judges, in part because of the judges' inability to review elections, and think only back to 2000 when, in Bush v. Gore, when that was handled peacefully by our legal system. But in addition to the independence of the judiciary, our legal system is dependent also on the independence of our legal profession. Some criticize the courts as activists, and we hear of activist judges. But the fact is the courts of this state and nation do not give advisory opinions. They don't go out and look for interesting cases. Lawsuits must be brought on behalf of litigants in real controversies with real issues. The Constitution would be an interesting, historic piece of paper containing aspirational guidelines if there were no lawyers bringing lawsuits on behalf of their clients whose rights have been violated by the Constitution. And to go back for a moment to Charles Ryan, who not only conceived of Law Day, he argued Baker versus Carr, establishing the role of the federal courts in elections and establishing the one man, one vote principle. That shows how much a lawyer who never held public office can do in this great nation. In this country, we as lawyers have the freedom and independence to bring lawsuits against the federal government, the state government, and other powerful interests without fear. Again, in contrast to China, where lawyers can be taken away or disbarred if they defy the government. Each age of our nation's history brings new attacks on these principles, and we have them today. Today, when members of Congress, in reaction to the Supreme Court decision in Kelo, refer to the Supreme Court as czars and engage in other personal attacks, and when members of Congress threaten to investigate federal judges they do not agree with, they are attempting to undermine the independence of the judiciary, and it's the role of the New York State Bar Association and all bar associations and all lawyers to answer those attacks. Today in this state, the failure to provide pay increases for judges since 1999 has in effect reduced the judiciary's salaries during their terms. And it has forced the judiciary to come to a co-equal branches to seek what they are entitled to. Therefore, the Chief Judge's proposal for a quadrennial commission to take judicial pay out of the political arena must be adopted. Today, when prosecutors, state and federal, ask that the attorney-client privilege be waived in determining whether or not clients are to be sentenced or indicted, undermines our independence and strikes at the heart of what we do, and we've spoken out against that principle. Today, when legal services are denied to a great number of our citizens because of lack of funding, and the rule of law and access to our courts is denied to them, then the rule of law is undermined. We can have the best legal system in the world, which we do, but if access to the courts is denied to a great number of people, then for them, there's no legal system at all. And we are deeply grateful to the legislature for restoring legal services for the poor, while funding for legal services for the poor, while we continue our quest for permanent and adequate funding. In addition to dividing the government into three parts, checks and balances also flow from our federal system, in which power is reserved to the states, thus further dispersing power. Yet today, Congress is legislating in areas previously clearly reserved to the states. Those intrusions have included attempting to impose new federal rules of sanctions and other measures in state courts, and we are vigorously opposing it. And they're attempting to impose a national tort system on the states, even though that has been an area reserved to the states. And we are fighting that as well. The legal system, finally, depends on public confidence. And today, when public officials and special interest groups seek to undermine that confidence, they are undermining the legal system by saying that there is an explosion, a litigation explosion in the state and nation when there isn't. When they blame on the legal system society's ills which they themselves cannot cure, whether it be increasing cost of products or not having obstetricians in small towns, and in many other countless ways, blaming the legal system, they are undermining that system. And it's up to us to continue our effort to counter such attacks. We must respond to these dangers, to the separation of power, and we must be vigilant for new dangers. But we must do so with a great sense of optimism and hope, because our great legal system, with an independent judiciary and an independent bar, will long endure. Happy Law Day to us all.
Thank you so much, President Bizarre. See, you don't need 13 more times delivering a message to get it right. You got it right the first time you tried. And now I'd like to call on our fabulous Chief Administrative Judge, Jonathan Littman, for the presentation of the Merit Performance Awards to several of our employees. The employees of the Unified Court System are, of course, the great strength of our court system, and we are so pleased to make these special awards today. Jonathan?
Good afternoon. I'm delighted to be here with all of you at the annual Court of Appeals Law Day to present the court system's Merit Performance Awards. We as Americans have set aside Law Day to reflect upon and celebrate the rule of law and what it means to our society. Law Day provides us with an ideal opportunity in these beautiful surroundings to recognize those members of our court family who in their day-to-day professional and personal lives epitomize the highest standards of public service. Today we honor 5 very special individuals who have inspired us by the selfless and valuable contributions they have made to their communities, their workplaces, and their fellow Americans. I'd ask Kimberly Kozlowski to come up to the podium, please. Kimberly Kozlowski is receiving a Merit Performance Award for superior work performance. She's a principal court analyst, Onondaga County Drug Court. For more than a decade, Kimberly Kozlowski has been the driving force behind the successful operations of the Syracuse Treatment Court in Onondaga County, and more recently, the county's Family Treatment Court. Over the years, as the caseloads have grown, Kimberly has worked continuously with a broad range of court and justice system officials to constantly improve the treatment court and maximize the efficiency and effectiveness of the services provided. Kimberly has been a pioneer in the drug treatment court movement, serving as secretary to the board of directors of the New York State Association of Drug Treatment Court Professionals and sharing her expertise with others as a lecturer at the state and national levels. Her great knowledge and passion have been recognized by her peers, who have given her the Sherry Lintz Drug Court Award. New York State's problem-solving courts have spawned a national, even an international revolution in the adjudication of nonviolent, addicted criminal offenders. But we never could have realized the full potential of this great innovation without the tremendous dedication of people like Kimberly Kozlowski, who have made it their life's work. Kimberly immediately understood and embraced the power and possibilities of problem-solving courts because she was able to see how treatment courts can rescue people from addiction, crime, and incarceration and return them to their families and to positive and productive lives. It is our great delight to recognize Kimberly Kozlowski for her outstanding contributions to the growth of drug treatment courts in New York State with the 2006 Merit Performance Award for Superior Work Performance. Would Elizabeth A. Taylor, Esquire, please come up to the podium? Merit Performance Award for Outstanding Educational Efforts, Principal Law Clerk, Bronx County Supreme Court, Elizabeth A. Taylor, Esquire. In 1995, Elizabeth A. Taylor returned to her native Bronx with a law degree and a dream: connecting inner-city youth to our justice system. This creative and dynamic woman started the Thurgood Marshall Jr. mock trial program for 7th and 8th graders, and thanks to her tireless leadership and efforts, this program has become a regional phenomenon with over 900 student participants this year alone. Elizabeth has made this her personal crusade, nurturing relationships with area schools, recruiting attorney volunteers to coach and mentor the students, and working closely with the program's board members to select cases that are meaningful to the students and calculated to teach them valuable life lessons. The Thurgood Marshall Jr. mock trial program is a truly inspiring example of how one person's vision and commitment can make a difference, and of how we can find concrete, meaningful ways to teach young people about the value of courts and lawyers in our society. Elizabeth Taylor has rolled up her sleeves and is successfully tackling one of the most pressing challenges facing the legal profession today, improving public understanding of our legal system. And when she is not challenging students to expand their horizons and develop their self-confidence and public speaking skills, she holds down a demanding job as a highly regarded principal law clerk in the always hectic Bronx County Supreme Court. Elizabeth, for your extraordinary leadership and creativity in building a law-based program that is educating young people about the justice system and putting them on the road to realizing their dreams, it is our honor to present you with this year's Merit Performance Award for outstanding educational efforts. Would Anthony Jimenez please come forward? Merit Performance Award for Community Service and Humanitarian Pursuits, Anthony Jimenez, Management Analyst, Nassau County Supreme Court. When it comes to community service, Anthony Jimenez of the Nassau County Supreme Court has no peer. This Purple Heart recipient, certified EMT, and former chief of the Glen Cove EMS has answered over 5,000 emergency calls in his day, including one in his own courthouse when he used CPR and a defibrillator to save the life of a juror experiencing a heart attack. Aside from his many years of selfless service as a first responder, Anthony takes time to teach first aid to local Boy Scouts and Girl Scouts, mentors local children, and goes out of his way to provide support to the parents of children serving overseas in the armed forces. This true pillar of his community serves as a member of the Glen Cove Council and the Glen Cove Drug-Free School Committee, is a liaison to the Glen Cove Youth Board, and a key member of his local American Legion. At a time when so many Americans seem to be retreating from civic participation into their own personal pursuits, it is involved citizens like Anthony Jimenez who keep the fabric of our communal life strong. His willingness to sacrifice so much of himself to help others in their time of need teaches us a lesson in civic responsibility and in what it takes to keep our communities healthy and vibrant. We thank you, Anthony, for being the quintessential public servant that you are. You are a source of pride and inspiration to your community and our court family, and we honor you with this year's Merit Performance Award for Community Service and Humanitarian Pursuits. Would Senior Court Officer Frank Pastore please come forward? Merit Performance Award for Heroism, Frank Pastore, Senior Court Officer, Queens County Supreme Court. One morning last November, Senior Court Officer Frank Pastore was on duty outside the Queens County Supreme Court when he heard the sounds of a dispute. As he responded to the disturbance, he saw a man repeatedly punching a woman seated in her car in an apparent effort to steal her vehicle. Officer Pastore did not hesitate for a moment. He rushed to the woman's aid, physically subdued her attacker, and handcuffed him. Thanks to Officer Pastore's courageous intervention, the victim, Patricia Klein, suffered only minor injuries. The traumatic memories of that attack will never leave her, but thankfully they will always be outweighed by the much brighter memory of Officer Pastore's selfless actions. In the words of Patricia Klein, "Thank you for my family and friends whose lives would have changed forever if they had lost me. Your family must be so very proud of you, and they probably don't even know how humble you are about being a hero. You didn't even want to tell me your name. Thank you from the bottom of my heart for shining like a bright light in the darkness when I thought that I was going to die." While neither Patricia Klein nor Officer Pastore knew it at the time, they were dealing with a very dangerous and desperate assailant who had just stabbed another woman and stolen her vehicle before crashing and abandoning it near the Queens Courthouse. Thanks to Officer Pastore's brave and decisive action, Miss Klein was saved from serious injury, and a dangerous criminal was brought to justice. Frank, your great valor, sense of duty, and humility have touched us deeply. It is with the greatest pride that we present you with this year's Merit Performance Award. And now, Chief Judge Kaye will present a Special Merit Performance Award for exemplary service and dedication to a revered member of the Court of Appeals family. Thank you.
Thank you, Judge Lippman, and congratulations to all of the award winners. It is now my privilege to present the final award, regrettably posthumously, to John J. Matthews, Esquire, in recognition of exemplary service and dedication. And I wonder, Ellen Matthews, if I might ask you to come forward while I describe your dad, a truly unique, unusual, and wonderful human being to so many of you here in the audience who knew and loved him as I did. In the spring of 1948, Court of Appeals Judge Charles Desmond invited a young solo practitioner in his hometown of Buffalo to serve as his law clerk, and on June 14, 1948, John J. Matthews, he was Jack to all of us, began his Court of Appeals career. Chief Judge Desmond completed his tenure in 1967, but Jack did not. Jack remained on with the court as consultation clerk until September 27, 1990, an astounding total of 42 years, 3 months, and 13 days. It was a legendary tenure in every sense. As consultation clerk, Jack reviewed every draft and final opinion in cases on appeal, and every internal report on motions and appeals filed with the court. He attended all of the court's confidential conferences, advising the court concerning its jurisdiction and the order of disposition in pending cases. Beyond this, Jack was the court's institutional memory. He spoke in intricate detail of its history, not only of its policies, procedures, and holdings, but also of its judges and staff, its traditions and transitions. We never tired of hearing Jack's stories, and sometimes we heard them many, many, many times over. During his tenure, Jack served 5 chief judges, 32 associate judges, and 5 clerks of the court. He left his mark on 105 volumes of the New York Report's first and second series. Jack himself was an imposing figure, always impeccably attired. But when he presided at his desk in the conference room, framed by the Archangel Gabriel atop St. Mary's Church out the window behind him, he took on an added dimension of authority and finality, and believe me, he sure did use it. The first time Jack asked to come up to my chambers when I was a brand new judge here to raise a technical question about one of my writings, I was absolutely terror-stricken. I carefully arranged not to be seated behind my desk. I thought about this for a long time, thinking that it would be much better if Jack and I sat in chairs alongside one another as equals. Imagine my surprise when Jack marched into my chambers, brushed past me, and took the seat behind my desk. What a message that was. Jack Matthews molded and inspired generations of law clerks and generations of new judges. We all very quickly came to realize that the great imposing wizard, who knew absolutely everything there was to know about the Court of Appeals, was, beneath it all, a consummate gentleman with endless patience and a heart of gold. Jack Matthews epitomized the ideal public servant, working selflessly behind the scenes for the good of the court, its litigants, and the public. He had a classic Irish wit and charm, accented by a twinkle in his eye and a cap of white hair, yet always he was humble and discreet. Above it all, he loved the court and his place within it, and we loved and learned from him in return. For his extraordinary lifelong contributions to the Court of Appeals and to the entire court system, we are proud to present a special Merit Performance Award to John J. Matthews. This award is received by his daughter, Ellen Matthews, who is here today with her brothers, Bill and Bob Matthews, and her sister-in-law, Tina Gallagher. Ellen? And now I would like to call on extraordinary Michelle Perry, who will bring our ceremony, our Law Day ceremony, to a very rousing conclusion. Michelle? Okay. If you need me to sing with you, just let me know.
Oh, beautiful for spacious skies, for amber ways of gray, for purple mountain majesty above the fruited plains. America, America, God shed his grace on thee and crown thy good with from sea to shining sea. God bless America, land that I love. Stand beside her and guide her through the night with a light from above, from the mountains to the prairies, to the oceans wide with foam. God bless America, my home, sweet home. God bless America, my home, sweet home. Please join me. God bless America, land that I love. Stand beside her and guide her through the night with a light from above, from the mountains to the prairies, to the oceans white with foam. God bless America, my home, sweet home. God bless America, my home, sweet home. God bless you.
Thank you, Michelle. Thank you, all of you too, and your wonderful family. Wonderful. Thank you all so much. That concludes our ceremony. Have a great law day every day. Thank you, Michelle. You are